Welcome to the Leagles Educare podcast series. In today's episode, we shall be discussing about FIR, the First Information Report. What is an FIR? What are the contents of an FIR? What are the procedural aspects relating to an FIR? And much more. I'm Martha Philip and that's my co-host Ajit. And today we will be talking about FIR. What is an FIR and why is it called an FIR?
So whenever a cognizable offense is committed, the informant will go to the police officer and he will get his statement recorded. This statement is called FIR and it is recorded under section 173 subsection 1 of Bharatiya Nagrik Suraksha Sanhita. It is a new law. It has replaced old CRPC 1973. Earlier, the procedure for lodging an FIR is provided in section 154. Now in 173. So basically the main object of FIR is to set the criminal law into motion. And why FIR is called FIR? Because after the incident, it is the first information that is recorded in writing. It is first in point in time. That is why it is called First Information Report.
Right. What are the procedural aspects which are explained in section 173?
Section 173 subsection 1 says that whenever a cognizable offense is committed, the informant will give his statement to the police officer. So this statement or information, it can be oral, it can be in written form, or it can be in electronic form. If it is in oral form, then the police officer will reduce it into writing. Or if it is in written form, then the police officer may consider that itself as an FIR, or he may reduce it into writing, and it shall be read over to the informant and it shall be signed by the informant. And if it is in electronic form, the police officer will record that information and it shall be signed by the informant within 3 days of recording.
Right, so the information can be given in oral form, written form, or in electronic form.
Yes.
Right. Are there any specific provisions for women and mentally disabled people?
Yes, there is a proviso to section 173 subsection 1. It says that offences committed against a woman, the FIR shall be recorded by a women police officer. And if the victim is mentally or physically disabled, then the FIR shall be registered at the place of residence of the victim, or at any convenient place of her choice, and it shall be in the presence of interpreter or a special educator, and it shall also be videographed. And the police officer shall get the victim's statement recorded under section 183 subsection 6 clause A before a judicial magistrate. And there are other procedural requirements of lodging an FIR. So FIR shall be signed by the informant. It shall be stamped or signed by the police officer in charge. There shall be no cutting in the FIR. If there is a cutting, then the informant and the police officer in charge will sign on that, and the judicial magistrate may seek explanation regarding that cutting. Right? And if there is an excessive cutting in the FIR, then it will diminish the value of FIR.
Right.
Yes.
Now, what are the contents of an FIR?
So जब भी हम FIR लॉन्च कराते हैं तो उसके अंदर बहुत सारी डिटेल्स मेंशन करनी होती है, सच एज जो नेचर है ऑफेंस का वो कॉग्निजेबल होना चाहिए, वेदर द इन्फॉर्मेंट इज एन आई विटनेस, उसने खुद से देखा है या फिर वो हियर से विटनेस है, उसने सुना है, अक्यूज्ड का डिटेल डिस्क्रिप्शन देना है, उसके आइडेंटिटी जिससे हम उसको आइडेंटिफाई कर सके, जैसे उसका अप्रोक्स एज क्या है, नाम क्या है, उसकी हाइट क्या है, कलर क्या है, ये सब चीज़ें, और विक्टिम की आइडेंटिटी, उसका नाम, विटनेसेस के नेम, एड्रेसेस, द मैनर इन विच द ऑफेंस वॉज कमिटेड, उसमें अक्यूज्ड का क्या रोल था, कौन सा वेपन यूज़ हुआ, कोई मोटिव है तो वो लिखना है उसके अंदर, और कोई सामान जो अक्यूज लेके भाग गया या उसका कोई सामान जो छूट गया है, जैसे कि फुटवेयर छूट गया उसका, या फिर कोई फिंगरप्रिंट, फुटप्रिंट्स एट्सेट्रा, ये सब हमें FIR के अंदर मेंशन करने हैं.
Right. Is registration of FIR compulsory? Is it mandatory?
It is mandatory because the Supreme Court has in numerous cases said the lodging an FIR is mandatory for a police officer. It is not a discretionary power.
Right.
So in a landmark case, Lalita Kumari versus State of Uttar Pradesh, it is a 5 judges bench judgment. The Supreme Court said the main object of FIR is to set the criminal law into motion. It is a documentation of initial facts so that later the police officer will not be able to make any alteration. So it is to prevent any foul play by the police officer, and it is also a first step towards providing justice to the victim, because it gives an assurance to the victim that criminal process shall be initiated against the accused. So lodging an FIR is compulsory, and if later the FIR is found to be false, the police officer can always refuse to investigate, or he can submit occurrence report to the judicial magistrate. And the Supreme Court said reasonableness and credibility is not a condition precedent for registering an FIR. It is a condition precedent for arrest. So arrest is discretionary power. Lodging an FIR is not discretionary, it is mandatory. So it is not for the police officer to see whether the information given to him is credible or reasonable. If there is a prima facie case, that information is that prima facie case that the cognizable offence is committed, he shall register an FIR.
And what if he refuses to do so?
Then there are remedies provided in section 173 subsection 4 itself.
Okay.
It says that if a police officer in charge refuses to lodge an FIR, the applicant or the informant can approach the superintendent of police. The superintendent of police can investigate the case by himself, or he may direct a subordinate police officer, and then he will conduct an investigation, and he shall have all the powers of investigating officer. And if that also not happen, then you can file an application before a judicial magistrate. It is also provided in section 173 subsection 4. Earlier it was not there. So judicial magistrate has power under section 175 clause 3 that he can order investigation. If that also not happen, you can file a formal complaint under section 210 subsection 1 clause A read with section 223 of Bharatiya Nagrik Suraksha Sanhita. If that also not happen, then you can approach the High Court under section 528 of inherent powers of the High Court. So generally you do not go to the High Court directly, because the High Court will not entertain your petition unless you have exhausted all your alternative remedies.
Right, going to the High Court is the last resort.
Yeah, yes.
So if the police officer denies registration of a FIR, then you can go to the superintendent of police. If that doesn't work out, then the judicial magistrate, you file an application, or you can also file, if that also doesn't work out, then you can file a complaint, a formal complaint, and the last resort that comes to us is obviously the High Court.
Yes. So there is a new provision added in section 173, and which was not there in 154 of CRPC. 173 clause 3 subsection 3 talks about the preliminary inquiry. So whenever a cognizable offence is committed and the offence is punishable for 3 to 7 years of imprisonment, then the police officer in charge can, with the prior permission of Deputy Superintendent of Police, conduct a preliminary inquiry to ascertain whether there is a prima facie case. If there is a prima facie case, he can register an FIR and he can start investigating the case. If there is no prima facie case, then he will not lodge the FIR or will not investigate the case. So it is a newly added provision. It gives a discretionary power to the police officer.
This was not a part of 154, section 154 CR in the CRPC.
Yes.
Right. Okay, now suppose the murder takes place in front of me in broad daylight, okay? And I don't want to be a part of the hassle, so I call up the police station and I give them the information. I do not disclose my identity at all because I don't want to be away from this. Now this piece of information which I've already provided to the police officer, will be regarded as an FIR?
It will not be, because it is a vague or cryptic information.
Okay.
So what happens कि कोई भी offense commit होता है आपके सामने, आप उसमें नहीं पढ़ना चाहते हो हैसल में, तो आपने इन्फॉर्मेशन दी पुलिस ऑफिसर को कि एक ऑफेंस कमिट हुआ है. पुलिस ऑफिसर क्या करेगा, वो स्पॉट पे जाएगा, वहां पे ही विल फाइंड अ विटनेस, उसके स्टेटमेंट को रिकॉर्ड करेगा फर्स्ट, then he will start investigating. तो जो statement record किया है, it will be considered as an FIR.
Okay.
Yes.
Another situation comes up to my mind. A theft takes place in Saket, okay, and FIR is filed in Saket, and the stolen property was jewelry. Now this jewelry is found in Connaught Place, and another FIR is also filed in Connaught Place. Now these two FIRs, are they? Do they have value? Do they hold value?
So it is a case of multiple FIR of regarding the same offense. So एक offense के लिए आप एक ही FIR lodge करा सकते हो. तो in this case one FIR will be cost and normally subsequent FIR will be cost. जैसे कि इस केस में Connaught Place पे बाद में FIR lodge कराई गई है, वो cost हो जाएगी.
अच्छा, this is a case of multiple FIRs.
Yes.
Right. Another situation where A and B get into a fight, a physical fight, and A files an FIR against B and B does the same. Right? So two FIRs are filed for the same offense. Both of them have a right to file an FIR, right?
So it is a case of cross FIR. Both, like you said, A and B both have right to file an FIR. So A अपना FIR lodge कराएगा, B FIR lodge कराएगा. दोनों में से कोई भी cost नहीं होगा. There will be two FIRs, there will be two trials. But both these trials will be clubbed together because witnesses will be the same. It is regarding the same offense.
Okay.
Yes.
What is the evidentiary value of FIR?
So evidentiary value can be divided into two parts of FIR. FIR is a relevant fact. So if it is lodged in the same transaction, it is relevant under section 4 of Bharatiya Sakshi Adhiniyam. It is also a new law. It has replaced Indian Evidence Act 1872. And the conduct of lodging an FIR is also relevant under section 6 of Bharatiya Sakshi Adhiniyam. If it is an admission, it is relevant under section 19. If the victim lodges an FIR and subsequently dies, it will be considered as a dying declaration. It is relevant under section 26. If there is a discovery statement, it is relevant under section 23 of Bharatiya Sakshi Adhiniyam. Procedural evidentiary value, it can be used to refresh the memory under section 162 of Bharatiya Sakshi Adhiniyam.
Okay.
It can be used for corroboration under section 159, 160 Bharatiya Sakshi Adhiniyam. It can be used to contradict the witness under section 148 of Bharatiya Sakshi Adhiniyam. It can be used in cross-examination as well.
Right.
Yes.
We've had a wonderful, educative and informative session today regarding FIR, the contents of an FIR, the procedural aspects of the FIR, not to forget the new provisions that have been added in the new Act, BNSS. Earlier, 154 of CRPST used to talk about FIR. Right now, we have discussed section 173 in detail. I hope you had a good time. If you do like our work, please like, share and subscribe our channel. And do get in touch with us through various social media handles like Twitter, Instagram and Facebook. Thank you for your time. Have a good day.